So I'm here with Mike Kennedy, who is bar counsel. Mike, I know you've been with the Professional Responsibility Program for some time. You've also been a member of the Board of Managers for some time. But there's probably a lot of people, a lot of our members who don't really know you very well or know a lot about you. So let's spend a couple minutes talking about your background and how you got to your current position.
Sure.
So let's start at the beginning. When did you get admitted to practice here?
I was admitted to the Vermont bar in February of 1994.
Did you go to law school here in the state?
No, I went to UVM, but then I went to George Washington Law School.
Okay. And I know you had some history with the AG's office. Is that where you started?
Well, I came back to Vermont after I graduated from GW and couldn't find a job, so I went and volunteered at the Chittenden County State's Attorney's Office and did my clerkship there.
The old days, the 6 months.
The old days, yeah. And at the time, Cindy McGuire was in that office, and Dan, who I'm now on the Board of Managers with, was an assistant AG in the Department of Corrections. An opening came in his office. He told Cindy, who recommended me to Dan, and I got hired, and I went to the AG's office in December of '94.
But the Department of Corrections?
Yes, Department of Corrections.
Were they in Waterbury?
We were in Waterbury at the time, yeah. All the Agency of Human Services attorneys were over in Waterbury.
And how long were you there?
I was there until '98. Then I stayed in Waterbury, did about a 9-month stint with what was then called the Department of Mental Health.
At some point, there was just one disciplinary counsel, right?
Ever since I've been there, there's been at least 2. When I first started, Jessica was the disciplinary counsel, I was the deputy, and Wendy was bar counsel. And Wendy's job was half-time. Then I became disciplinary counsel after Jessica left, hired a deputy, and Wendy was still bar counsel. And that's how it stayed up until about 2 years ago.
And about 2 years ago is when you became
2012, yep. Wendy moved to DC. I became bar counsel. They changed that position to full-time. Beth took my spot. She moved from deputy to the disciplinary counsel. They gave her a deputy, but only half-time. So we just restructured within the program.
The reason I asked you that about those positions, because I thought I remembered a budgetary issue at some point where there was, you were either going to have an investigator or a second lawyer. I
don't think that was ever the choice. There was, when I first started, there was an investigator, but then that spot got riffed. And doesn't, well, I guess it always exists even after a reduction in force. I'm not really certain.
But it hasn't been filled.
It's never been filled, yeah.
So let's talk about the different functions of, we've been using the term disciplinary
Yep.
counsel and bar counsel.
Yep.
So can you define what each does and so it's clear that how they are different?
Sure. Disciplinary counsel focuses on investigating and prosecuting ethics violations. Bar counsel, I'd have really 3 aspects to my job. The only involvement I have at all with an ethics complaint is initially when it comes in. There's the screening, it's called, and I screen it. And I decide, does it go to disciplinary counsel for a formal investigation? Does it get dismissed because it doesn't state a claim, so to speak? Or does it go to, we now have a diversion program, which is non-disciplinary resolution of an ethics complaint. So I do that. I also do inquiries. Lawyers and non-lawyers can call if they have a question about, usually it's lawyers who call and say, hey Mike, I got this going on, what do I do? And I point them to the particular rule or decision from the Supreme Court, try to help them make sure that they comply with the rules. And then I also do a lot of CLEs. Beth's job, and Kim Rubin, her deputy, if I refer them a complaint for investigation, they investigate it. And if they decide that there's been a violation, they're the prosecutors. So that's how the 2 different sides of the program work.
So if they decide to go forward with prosecution, that doesn't come back to you, they just
No, not at all. Once I refer them a complaint for an investigation, I don't have any more involvement with that file unless after they conclude their investigation, they decide to refer it back for a non-disciplinary resolution by one of our assistance panels. the assistance panels are the professional responsibility programs equivalent of diversion in the criminal
So that's
court.
what you meant when you said
Yes.
diversion.
I can send one there right away. If I'm not sure, this may need prosecution, maybe it's appropriate for diversion, I don't know, I can send it to them, they investigate it, they have the authority to send it back.
Okay. So who runs this entire operation?
On a day-to-day basis, we're the only people in the office. We work under the supervision of the court administrator, and really also the professional responsibility board runs the entire program.
So who's on that board? How's it made up? That
The board has 7 people. It's established in Administrative Order 9, the court's same order that establishes the entire program. Right now, the chair is Jan Eastman. She's been the chair for, I think, 4 or 5 years now. It's a 7-person board, 3 lawyers, 3 non-lawyers, 1 judge, and they are responsible for the general supervision and administration of both my office and Beth's office.
Okay. So let's go back to assistance panels versus hearing panels.
Sure.
Who makes up those panels, and how are they selected?
They are appointed by the court with a recommendation from the board. Right now, we have hearing panels in every part of the state. There are, I think, 10 total, and they're a standing panel. So they will sit as a panel with each case that's referred to them. By rule, each panel must consist of 2 lawyers and 1 non-lawyer. Those people are not on the professional responsibility board itself. They're volunteers who, whenever a case is assigned to them, they hear it as the judges. Assistance panels are a bit different in that if you're an assistance panel member, you don't sit on a particular panel. Whenever we have a case 3 that goes to an assistance panel, 3 people will review it, but it's not necessarily like if I were a panel member, I'm not always on with you, say. I could be, we assign those sort of as they come in. Each assistance panel must include 1 member of the board and 1 non-attorney.
As opposed to hearing panels,
Hearing panel
is a board member.
Hearing panel, a board member cannot sit on a hearing panel. A board member must be on each assistance panel that convenes.
So how many people do you have? I mean, it sounds like a pretty big operation.
Yeah, right now I think there are between 35 and 40 assistance panel members. There are 30 hearing panel members. So in total with the board, around 70 volunteers who are part of the program.
Hearing panels.
Hearing panels would be Beth or Kim complete their investigation. They decide that there's been a violation. So what they first have to do before they can simply charge a lawyer, they have to request a probable cause review. And that is an ex parte process where Beth or Kim summarize their investigation and their findings by affidavit, has to be by affidavit. Attached to that affidavit, any exhibits or evidence they have along with a memorandum of law, which goes to what's called a probable cause panel. Each year, one of those 10 hearing panels sits as the probable cause panel. And they review for probable cause the investigation. If they say yes, there is probable cause, then Beth or Kim is authorized to file formal charges. If the panel says no, there is no probable cause, Beth or Kim can either do more investigation or dismiss the case. Once it goes to a hearing panel, the probable cause panel isn't the same panel that hears the case itself. It would have to go to another hearing panel for a resolution. Sorry, I sort of lost track of your question.
No, you didn't. But the probable cause panel, is that a public hearing or confidential?
No, they don't even actually have a hearing. They do it on, Beth doesn't show up. I suppose there's nothing in the rule that would prohibit them from having a hearing, but they do it, as I understand it, the 3 members get together by phone and talk about whatever they have in front of them, and they issue a decision that either says probable cause found, probable cause not found. There's no written decision.
And at what point, assuming probable cause is found, what does disciplinary counsel do next? How does it start?
The next thing that happens is what would be the charging document, and that can happen in one of 2 ways. Disciplinary counsel can file what's called a petition of misconduct. It has a formal name, which in our system is the same as the complaint in the civil system. And it sets out the charges, and the respondent then has to either admit or deny, and then there's a discovery phase and then a hearing. The process can sort of be shortened by, in addition to the petition of misconduct, the parties can start it by stipulation, where they stipulate to the facts and then join to recommend particular conclusions of law and a sanction. Or they can stipulate to the fact and then have a hearing on what the sanction should be, or even if those facts as stipulated constitute a violation.
Right. So, I don't know the answer to, maybe I should know the answer to this, but I don't. Is there a time limit if that charging document is issued? Are there sort of procedural rules that put time limits on both sides here?
You're lucky you don't know the answer to
Yeah,
that.
I'm actually happy about that.
But yes, there are. Once the petition of misconduct is filed, the respondent has 20 days to answer, and then there's a 60-day discovery period from the date that the answer is filed. Now that can be extended, but in Administrative Order 9, it's set out, I think in Rule 11, that sets out that 60-day period.
So if a layperson had started the complaint, and you sent it off to the disciplinary side and an investigation started, until such time as probable cause was found, it's really not public. Is that right?
Even after probable cause is found, a complaint doesn't become public until disciplinary counsel files either that petition of misconduct that I mentioned or the stipulation of facts.
Right, so
that's the first document that becomes public.
I'm going to say that takes 60, let's say,
It could
hypothetically,
take,
it takes 60 days.
Sure.
If that person who filed the initial complaint calls you, or sometimes calls here, and says, I filed a complaint about lawyer X, and I don't know what's going on. How are we able to respond? How are you able to respond to that?
We would be able to respond to the complainant if they called and said, what's the status of my complaint? We would not be able to respond to anybody else because the confidentiality rule would preclude us from doing so.
Okay. So really what goes in on that disciplinary side is what you initially see is or may be a violation of our rules.
Right.
So when you get something that's short of that, which you think may eventually end up on the assistance panel side, what do you see? What do you get?
Well, that's a good question, and there's nothing in the rule to really help. And what I've done over the years, and I don't know that it's right or that it's wrong, but it seems to work, is the conduct that is not so serious as to warrant a prosecution or a sanction, but just is too serious to send the complainant a letter saying, we're not doing anything about this. Those are the cases that go to an assistance panel. And that's a wide range of conduct. It could be just a general low-level failure to stay in touch with your client, but where no damage resulted though, but still the client feels, hey, I wasn't listened to, I wasn't communicated with. It could be a situation where communication between the lawyer and the client just broke down, and a relationship broke down, and we try to get them back on the same page. I can't the assistance panel process is confidential, so I can't give you specific examples of cases that have been sent there, but it's generally where there's been just a breakdown in the communication between the client and the lawyer, or the lawyer has done something that isn't necessarily unethical, but falls in that old professionalism category where it really wasn't professional. And it's good sometimes for the lawyer to hear from other lawyers who sit as the assistance panel and try to help out that lawyer or get that lawyer to see, hey, this isn't the way to practice. We're not going to do anything to your license, but this wasn't what we expect of Vermont lawyers.
So a couple questions about that, respecting the confidentiality. Is it adversarial in any way?
The assistance panel process, it's not supposed to be. I've only been to probably 4 or 5 assistance panel hearings because I only started going as bar counsel. They have not been adversarial at all. I suppose if they turned adversarial, I don't think the process would work. And at that point, the panel could either say, we tried, it didn't work, you know, and that's the end of it, or they could refer it back to disciplinary counsel for an investigation.
So,
But my experience has been that it's not adversarial at all. It's more like it's really a learning process.
so how is the case presented at the assistance panel? You said you've only been to a couple of them. So there's a panel of 3 people.
Right. And what they have received ahead of time, either from Beth or from me, depending on who made the referral, the complaint, the attorney's answer, response to the complaint, and a short memorandum from us about why we're referring it to an assistance panel. So they've received all that. The parties, the complainant and the respondent, have been notified that it's been referred to an assistance panel and the reasons therefore. And show up, there's no, you know, opening statements or anything. The panel just starts with questions about, you know, why are we here? Tell us why we're here.
So
We start
they handle it
conversation.
themselves?
Yes, they handle it themselves.
Is the complainant invited to participate?
Most, usually, yeah. Sometimes at the assistance panel level, or on that side of things, the complainant doesn't want to come. They are satisfied that, hey, my concern was addressed, they're going to address this lawyer, that's fine. But more often than not, the complainant does come.
And is it sort of like a mediation? Is it sort
It's
of?
similar, but everybody stays in the same room the entire time. But it's similar, yeah.
Do you have, if I change the subject here quickly, do you have in mind kind of your caseload or the types of cases? I know you issue an annual report every
Yep.
year, probably about a month ago. This year's came out. Where are we? How are we as a bar in terms of these kinds of complaints, prosecutions, if you will, and you know, findings of misconduct?
Before I get to the numbers, I don't think, in all the time I've been there, I've decided that the number of complaints that my office receives, or Beth's office receives, oops, sorry about that, does not indicate where we are as a bar. Because, you know, there could be 500 complaints that have no merit whatsoever, or there could be 5 complaints that are significantly serious. So I don't track where we are as a bar based on the number of complaints that we get. That being said, the number of complaints that we get has been remarkably consistent year to year ever since I've been there. We generally get between 250 and 275. As of May 30th, I think we received 240, right around that area. Of those, 90 had been referred to disciplinary counsel for investigation. Excuse me, we hadn't received 240. We'd received about 190. There were others that don't come in as a complaint. I'm sort of getting astray here, but for instance, overdraft notices are reported. Overdrafts to trust accounts are reported to our office, and that is automatically given to Beth to investigate. I don't even screen those. Then Beth opens some files on her own based on information that she learns, for instance, in a newspaper report or a news report that doesn't come to us by complaint. But anyway, back to your question. I think we'd received 185 complaints or so by the end of May. 90 had been referred to disciplinary counsel to investigate further. 70 I had dismissed. The other 20 had gone to our diversion process. I think as a bar we're doing pretty well, because if you think about the number of individual interactions or decisions that an attorney makes every single day over the course of a year, times the number of attorneys that we have practicing law in the state, and we only get 250 complaints a year, I think that's a good sign.
And any idea where other states are or where
Don't.
we fit nationally?
I don't know whether the number of our complaints per attorney is, I don't know where that falls nationally. I just don't.
So you raised this issue about trust account overdrafts. I mean, that's still an ongoing issue.
It's an ongoing issue, and it's been, you know, Kevin, Ryan, and I did a seminar a couple days ago. We have had not a spate, but I think 4 trust account sanctions in the last 8 months. And that has generated some talk around the state that, trust account violations are up. And they're really not. Kevin and I mentioned in our seminar that some of the conduct that was sanctioned in the past year is the exact type of conduct that we sanctioned 10 years ago. It just happens that 4 came out within a very relatively short time period. But yeah, trust account violations trust account management is an ongoing issue, not just here, but there's some emails going around the National Organization of Bar Counsel listserv right now, where it's happening in every state. And boards and prosecutors and Supreme Courts are concerned that when are we going to get through to these attorneys? Because we keep seeing the same trust account mistakes over and over and over again.
And what are those?
Failure to keep proper trust account records, failure to segregate your fund, an attorney's funds from client funds. There's not, I don't want the message to get out that, whoa, trust account violations, attorneys are stealing money. That's not what we're seeing at all. It's just a failure to follow the rules on keeping track of client property, and then in some instances there has been commingling.
Huh, interesting. Anything more? Anything that I failed to ask you, or anything more you want to
No,
let our
not
folks know?
that I can think of. My experience when I first started, I thought, oh gosh, nobody's gonna like me because I'm gonna be coming around. This was 15 years ago. Maybe nobody did like me. I'm not even saying they like me now, but I think our bar.
You want to go into that?
Yeah, I think our bar is great. I think the vast majority of lawyers appreciate what we do, because I think they understand that it only takes one or two bad apples to give all of us a bad name, and we have very few bad apples. I think our bar is great.
There actually, now that you brought that up, there is one more thing I want to ask you, and that's your role as giving advice. You mentioned it at the very beginning,
Yeah.
about giving advice to lawyers. How often do people actually take advantage of that opportunity to talk to you?
Quite often. At the end of May, I had received, I think, 680 inquiries since last July 1st. 540, or right about there, had come from attorneys, the rest from non-attorneys. So I get a lot of calls, and I'm always impressed by the level of thought and care that lawyers are putting into the work that they do. Because a lot of them call me with questions where the choice they're going to make, it's not even questionable that they're making the right choice, but they're still calling just to make sure. And it's always struck me how much thought lawyers are putting into what they're doing every day.
So, do you run the risk, or do people run the risk of asking you a question and then maybe having you run across the hall and turn that into the disciplinary side?
They do not. I am not allowed, under the board's rules, to report to Beth or Kim something that somebody tells me when they call me. There may be times when I suggest that the person consider and make a self-report, but I am not allowed to tell anyone, what I hear when an attorney calls me with a question.
So if I call you with the question and you say, I think you can do that, whatever that is, and later I find myself with the complaint against me because I did what I thought you said was within the rules, do I have any benefit, do I have any defense there?
I think so, but the answer is I don't know. First, I try not to say I think you can do that, or you can't. Actually, I will say, you shouldn't do that. I wouldn't do that if I were you, Bob. I try not to say I think you can do that, not because I'm worried that I might be wrong, but I never really know if I have all the information. There are two sides to every story. So what I try to do instead is guide people. Okay, it sounds like you're dealing with a conflict issue there. So here are the conflict rules that you've got to look at, and here are some advisory ethics opinions from the Bar Association on conflicts, and here are some decisions from the Supreme Court on conflicts. Read these, decide what you want to do. To your question though, there have been one or two times where someone has called me for guidance, and then eventually a complaint was filed against that person on the exact topic or the exact conduct that they had called to ask about. Those people are free to tell Beth, hey look, I checked with Mike, and Mike said this, and if they sort of waive that confidentiality that applies to me, they're allowed to do so. Beth will check with me. And Beth and I have a pretty good relationship. We worked for a long time together. We're generally on the same page. But there is no rule from the Supreme Court yet that if you did what Mike said, you won't be prosecuted. So in theory, could it happen? Yes, it hasn't happened yet, and I doubt it would.
Great, great. Well, that's all the questions that I have.
Well, thank you. The Bar Association itself and the Board of Managers in particular have been great supporters of our program. And
Right,
we
they like
appreciate
you.
all the work that
Most people like you, Mike, so.
I don't know
I
about
think
that.
we're
They
good
say
about
they do. They don't even have to say so anymore. I realize that people still don't know that I switched over to Bar Counsel when I show up at a CLE and people go, "Ooh, Mike Kennedy's here."
Right.
Because I'm not even the prosecutor anymore.
Right, so
So
they don't
now
have to
they're
be nice
free
to
to
you.
tell me I'm a jerk if they think I'm a jerk, but they still haven't yet. So
And I'm
Yes.
sure they will. I'm sure they will. Thanks a lot for
No
coming
problem.
in and
Thanks
doing
for
this
having
with
me.
us today.
all right, thank you.